that we just had our lunch.
Very rough.
Hello Macari, hello world. This is Attorney Angel and I'm your legal angel. Still on learning, for this vlog I'm sharing with you legal research basics based from an audio recording I used last year for my legal research class. Enjoy listening. Discussion on legal research. We have already discussed that legal research involves the search for authority that can be applied to a given set of facts and issues. You also know that analysis is very much part of legal research. And legal research and analysis involve determining how the law applies to the facts of the case, which in turn requires knowledge of what the law is and how to find it, and the general principles that govern its application. Now, to support one's legal research and analysis, it is essential that you know the legal authorities and how to search for legal authorities. Of course, you know that legal authorities may be divided into primary authorities and secondary authorities. And these primary and secondary legal authorities may be properly cited when lawyers present legal arguments and when judges write their opinions. Now, with respect to legal researchers and even law students, aspiring lawyers like yourselves, reference can be had to statutes, regulations, and prior decisions to support your study or your research. Also, you may refer to secondary authority such as restatements, comments, annotations, treatises, journal articles, and academic articles. And also, remember that you must muster and master legal citation. Now, on the topic of legal citations, it is said that the presence of citations in one's work is considered as one of the hallmarks of an intelligently undertaken research. It shows that your arguments or your thesis statements are supported by extraneous sources other than your own, and that failure to cite materials taken from others' works can make you liable for plagiarism or even infringement of intellectual property of the lawful owner. Also, please take note of the following terms: bibliography, citation, and attribution. Let's go first to bibliography. Bibliography, the etymology is Greek. It is bibliographia, which literally translates to book writing. And in its most general sense, it is the study and description of books. It can be divided into enumerative or systematic. And this results in an overview of publications in a particular category and which studies the production of books. And in the study of the production of books, it can be analytical or critical. As to citation, it is essential in the legal profession because legal analysis depends on the examination of binding rules and norms. And it is imperative to determine with precision what these rules and norms are. So citation facilitates this determination. For attribution, it means ascribing a particular work or remark to a particular author or person. Okay? It is very important as a law student that you must learn effective use of authority to become successful and effective advocates of legal research and of certain legal principles. Okay. Now, there are several purposes of citation. According to the authors of legal research, Ang Po, Attorneys Ang, Dr. Ang, and Attorney Po, legal research provides support or contrast to assertions. Also, it allows proper attribution of non-original input. It also helps readers identify sources for further study or research. Take note that when citing multiple authorities, cite first the sources to which non-original ideas are attributed, or those authorities which directly provide support or opposition to the text. Okay? And there are also, according to these authors, different types of citation principles, including full address principles, other minimum content principles, compacting principles, and format principles. When you say full address principles, these specify completeness of the address or the identification of a cited document or document portion in terms that will allow the reader to retrieve it. When you say other minimum content principles, according to these authors, these call for the inclusion in a citation of additional information items beyond a retrieval address. So, the examples are the full name of the author of a journal article, the year a decision was rendered or a statutory codification was last updated, or some of these principles are conditional. They require the inclusion of a particular item under specified circumstances so that the absence of that item forms a citation represents that those circumstances do not exist. As to compacting principles, according to these authors, these are principles that reduce the space taken up by the information items included in the citation. And format principles are principles about punctuation, typography, order of items within a citation, and the like. Such principles apply to the optional elements in a citation as well as the mandatory ones. Now, after the midterm exams, part of the discussion on citation would include the APA style citation and the Blue Book citation, as well as we can compare it to the ALJ citation guide and other citation styles like the Chicago style of citation and the Language Association citation style. Last week, we centered on the cases of Habana versus Robles and in re plagiarism against Associate Justice Mariano del Castillo. Now, just a review on plagiarism and its concept. Under Black's Law Dictionary, aside from the definition given in the case, plagiarism is defined as the act of appropriating the literary composition of another or parts or passages of his writings or the ideas or language of the same and passing them off as the product of one's own mind. If the material is protected by copyright, such act may constitute an offense of copyright infringement. Such was in the case of Habana versus Robles. And to be liable for plagiarism, it is not necessary to exactly duplicate another's literary work, it being sufficient if unfair use of such work is made by lifting of substantial portion thereof. But even an exact counterpart of another's work does not constitute plagiarism if such counterpart was arrived at independently or on your own. Basically, plagiarism is intellectual theft. Citing one's sources is the fundamental trademark of a true and intelligent and honest and ethical legal researcher. Now, with respect to fair use is privilege to use the copyrighted material in a reasonable manner without the consent of the copyright owner or as copying the same or ideas or the theme or the ideas. In copywriting books, the purpose is to give protection to the intellectual product of an author. And this is protected under the copyright law or the intellectual property law under Section 184, 1B. So quotations from a published work, if they are compatible with fair use and only to the extent justified by the purpose, including the quotations from newspaper articles, periodicals, etc. in the form of press summaries are allowed, provided that the source and the name of the author, if appearing on the work, are mentioned. So no question of fair or unfair use arises if no copying is proved to begin with. This is in consonance with the principle that there can be no infringement if there was no copying. So in fair use, it involves a balancing process by which a complex of variables determine whether other interests should override the rights of the creators. One should also take care not to include in your research output any information that is privileged or confidential without the proper authorization. Otherwise, you may be open to prosecution, criminal prosecution. So always remember the rule of thumb. Always acknowledge your sources. As two materials, we have legal materials, non-legal materials, and electronic sources. Now, for legal materials, like for example, we have law dictionaries, encyclopedia, legal articles, and annotated works. And they may be cited indicating the title of the work, the name of the author, the name of publication or publisher, the page, if applicable, the place of publication, and the date of publication. Now, for non-legal materials, we have examples. For example, news reports, which we indicate by title of the news or the work, and then the name of the media and the date. For electronic sources, we cite the URL address. The sources from the internet can be cited in many ways, but also indicate the website and also when you last access or last retrieved the same information. Okay. While citing your sources may seem tedious at first, it is considered a good discipline to inculcate this practice in your legal research and in your legal study, because this is a sign of respect to the owner's work. It is a stamp of an intelligent, honest, ethical, legal researcher. So just for the citations, citations may be placed as footnotes and notes and in-text citation. Thank you very much for listening. Like, subscribe, share, and follow. Be kind, be a blessing to others, glorify God with a grateful heart. This is Attorney Angel, and I'm your legal angel.